Good afternoon or good evening, everyone, or good morning, depending on where you're coming to us today in the world. Welcome. It's a delight to have you here. I'm Dr. Pamela Crisco. I'm one of the founding board members of the Psychedelic Association of Canada. Absolute delight to be here with everyone today. We'd love to know where you're coming to us from, so feel free in the chat to put where you're from. Love to know that across Canada, I'm sure, and some in the US as well. I'd like to first off acknowledge that I'm coming to you today from the unceded territory of the Klahoose First Nations, the Tla'amin First Nations, and the Hamalko First Nations. And I feel very privileged to be able to live and work where I do. We're also in an epic winter windstorm today. So if we've got some contingency plans in case the wind knocks us off. So as long as Paul stays on, the webinar will continue on. But if you lose me, don't worry, I'm probably under a fallen tree, but I'll be okay. We have some great stuff coming up in the near future, some more webinars. December 4th, we have a webinar focusing on ketamine-assisted therapy and its use with veterans. So we hope that you'll come with that. There'll be a lot of great insights there, outcomes, topics around the therapy use of it and how we can move this forward for everyone. And again, part 2 of the End of Life series is going to be January 15th. So we welcome you to join us with that. Many of you know this, the Psychedelic Association of Canada is pretty much 99% volunteer run. It's run by all of us, people like you. We all hands on deck helping out, all sorts of projects that we work on to move the bar forward. Hopefully, moving us all closer to having legal access to these wonderful medicines. And so your support is so helpful. The membership you buy, that helps these webinars happen. They help pay for the technology. They help everything we're doing, the ethics working group, the website, all this great resources on the website and more. Upcoming in the near future, we're going to have some wonderful Ask Me Anythings with some surprise and wonderful guests. So you'll have an opportunity to do that. And right now, if you are a member and you've received our member survey, really want to encourage you to do that because if you do our member survey, you will be entered in a draw for a signed book from Paul Stamets of his most recent book, Psilocybin Mushrooms in Their Natural Habitat, and that will be autographed to you, signed to you. So please do that. We really want to know what you want, what you think the Psychedelic Association of Canada should be doing, because this is your organization. And we're really honored that you're here. So again, put in the chat where you're calling in from. It's great to have you. So today's webinar is on psilocybin in the freedom of thought. And so our special guest today is Paul Lewin. So I'm going to hand it over to you, Paul, to introduce yourself and tell everyone that's watching a lot more about you and what you do.
So I describe myself as a cannabis and psychedelics lawyer. I'm a lawyer practicing in Toronto for the last 30 plus years. I have a particular focus on constitutional issues related to all drugs, but especially cannabis and psychedelics.
Okay, I think that's the shortest I've ever heard a lawyer or barrister talk. That's okay. So we'll dive right in because that's what people are here to hear about. So tell us about this freedom of thought psilocybin case.
Thank you. So in the case, I argued that psilocybin is a freedom of thought tool and that all Canadians should have legal access to psilocybin. Freedom of thought is a charter right that's never been argued in Canada before, so this was all new ground. In Canada, charter tools are protected. There's a long history of that. I said that psilocybin allows people to more fully experience thought. The judge dismissed the application. I just recently received the decision. The judge applied a freedom of thought test that makes no sense, and he ignored our extraordinary evidentiary record. It is a flawed decision. It's not a superior court, it's a lower court decision. and this absolutely has to be appealed to the Ontario Court of Appeal, which is the highest court in Ontario. We put forward a deep ocean of evidence, and it would be a terrible shame if that were wasted. I'll briefly describe the two main reasons the judge dismissed our application. First, the judge applied an ill-fitting test for a freedom of thought tool. And this test was invented or created by the judge, and that might seem weird, but that's because freedom of thought's never been argued before. So we were all creating this for the very first time. But he created a terrible test, and I'll describe it to you. The judge's test required that a freedom of thought tool, in order to be protected, must be predictable in that a particular effect can be expected, or that one will have a specific thought. This test does not work. One could never predict what specific thoughts a freedom of thought tool might cause one to think, even though it may be perfectly reasonable to use that tool for freedom of thought purposes. For example, if we take a classic freedom of thought tool, such as a philosophy book, the thoughts that one would have from reading a philosophy book could never be predicted while reading or after reading. Despite that, it's very reasonable to use a philosophy book for thought-related purposes. A psychotherapist is another classic freedom of thought tool. After a session with a psychotherapist, one could never predict what specific thoughts one would have. It is an impossible test that would never succeed for any freedom of thought tool, or for any freedom of thought tool. It will always fail because the precise thoughts you will have during any experience can never be predicted. But that does not mean there is no such thing as a freedom of thought tool. A test that better fits a freedom of thought tool is my proposed test for in which I say a freedom of thought tool, in order to be protected, must be reasonably, this is viewed objectively, and seriously, viewed subjectively, used for thought purposes. With psilocybin, like a philosophy book, you might not know exactly what you're going to think, but it is reasonable to use it for thought purposes. The requirement that it be reasonably used for thought purposes avoids people claiming something as a freedom of thought tool when in fact its connection to thought is limited. A freedom of thought tool must have a strong connection to thought, viewed objectively. The requirement that it be seriously used to more fully experience thought avoids people claiming something as a freedom of thought tool when the thought benefits, they might be there, but they're modest. It should be a serious tool with an objectively confirmable connection to thought. In addition to having an unworkable test, the judge failed to acknowledge the mountainous evidence we put forward connecting psilocybin to thought. The judge said, psilocybin has a remote relationship to thought, if you can believe that. Those might be the most wrong words ever written about psilocybin. The evidence overwhelmingly showed certain types of thoughts commonly emerge during a psilocybin experience. The judge's factual findings on psilocybin's thought-related effects can be found in two small paragraphs. There were hundreds of pages of transcripts and exhibits on psilocybin's thought-related benefits, and yet the judge's findings on this key issue could fit in a thimble. Strangely, the judge did find that psilocybin causes cognitive flexibility. Cognitive flexibility is a thought-related benefit. The judge found that psilocybin increases neuroplasticity and that with the assistance of a therapist would enable new thought patterns to develop. That's a thought-related benefit. He writes this out and says, well, we don't know, but the problem is we never know exactly what you're going to think. All three psilocybin experts, we had two, the government had one, said psilocybin causes mystical and spiritual effects. But the judge did not find that as a fact. The judge accepted the government experts' comments about the less pleasant psilocybin effects, but he did not accept the government experts' evidence on the positive effects of psilocybin, such as and these are the words of the government expert, creativity, peace, transcendence, unity, oneness, numinous, deity encounters, social connectedness, and empathy. Even the government expert admitted that psilocybin produces deity encounters. I cannot imagine a thought related experience more important, more profound than meeting God. And somehow the judge missed that. The judge's, but that wasn't the judge's greatest error. The judge's greatest error on his evidence was his misunderstanding of Professor David Nutt's powerful and extensive evidence. And I suspect almost everybody on this call has heard of Professor David Nutt. He might be the leading expert in the world on psilocybin. He was on the stand for 3 days. This wasn't short. And we had lots and lots of exhibits filed as part of his evidence. We were blessed to have him on the case as our expert. He testified that the vast majority of people who use psilocybin get a sense in which they are more connected either to themselves, to other people, or to nature. He gave evidence that it's very common for a psilocybin experience to include a feeling of unity or understanding of a greater being or a greater presence or something beyond the human psyche. He said that psilocybin induced changes in consciousness that tend to go hand in hand with changes in spiritual feeling and mysticism, and that those changes in consciousness are predictive of later benefits. He said that it's very common for people who have used psilocybin to develop new values and perspectives. He testified that the memory of the spiritual, mystical, and/or religious experience persists forever. He stated that it's very common for a person who uses psilocybin to develop new values or perspectives. He testified that people who have that experience tend to report themselves as being more spiritual ever after. Somehow the judge missed all of that. I could talk all day about this, but those are really the two main problems, is a completely dysfunctional test for thought, and he seemed to ignore a vast amount of evidence. The judge said some things that were good. He left the door open to appeal. This has to be appealed. But that anyway, that's sort of a short overview of why we were not successful. Oh, you're on
Unmute
mute.
myself first. Let's circle back and bring people, now that you've said what you presented, the evidence, and I'm sure we'll revisit some of the evidence again and the decision, even in more depth. What brought this case forward? What was, how did you get involved? What was the case that you were?
Sure. So I had a client of mine. I had done some work with some people involved with Fun Guys, and I was representing a gentleman who was a spokesperson for Fun Guys, a Fun Guys store, and they charged him with possession for the purpose. And some of you may have heard of Fun Guys and think of them as a group who he was very passionate about bringing these issues forward. He really cared deeply. Some say they were only in it for the money, but he really wanted to bring this forward. He could have gotten out of this case with just a slap on the wrist, but he said, I really want to argue these issues. I want to change this forever. And he's now left the country. He had to flee the country for his safety. Samar Akila is his name. It was a great honor working for him. He's in Egypt now. Um, he the appeal can't go forward. He has no money and he's not in the country. So I am in the process of looking for donors. So if anybody out there knows someone who wants to support this important issue, I have a short window to bring my appeal. And it's not like we're starting from scratch. Like we have done so much already, but it has to be appealed. The foundation is there. But anyway, that's how I don't mean to get off track. So
Yeah, and I think there's been a lot of people in Canada that have been hoping to be arrested and brought before the law to bring things to the Supreme Court. And so it sounds like this was one that happened, but it wasn't necessarily, it was not necessarily what he was hoping for, but then he saw that this was a good argument to be brought forward to the courts.
yes, yeah, no, he was very passionate about it. We discussed it extensively, and the strange thing about this thing is the judge was. You might be some of you might be thinking this judge was not very engaged. He was absolutely engaged. He was so like he really seemed to care deeply about these issues. And and then at the end, I get this decision, which it almost seemed like he ran out of time, and he just wrote something fast, and it would just be quicker to agree with the Crown than it would take to explain how the law has to be taken down. But
Right. And I want to move forward in this, but I also, before I do that, I want to actually move back in time because this, if I recall, sounds very, and you're a you work with cannabis. This sounds very familiar to the first time, the first arguments around bringing cannabis, where cannabis was compared to cannibalism. Dude, do you recall those decisions at the Supreme Court level?
well, cannabis compared to cannibalism, I'm not sure about that. I mean, I will say this, that, and I know studies are great, and research is great, and it's great that it's moving forward. But, you mentioned cannabis, and there would have been cannabis. The only reason they made medical cannabis legal in the first place was the charter, and
Mm-hmm,
that they were
mm-hmm,
forced to do it. And this was
mm-hmm,
a decision in 2000, and the government would have never done it. There was no goodwill there, and they just want to preserve the status quo and not rock the boat. And they were forced to do it because of the charter. So the charter is really something amazing we have in Canada, in which we can force governments to act in a certain way. And really, this tool is here. So if we win at the Court of Appeal, they will be forced to make it legally available to all healthy adults, subject to reasonable limits.
right. So what's the error the judge made? There's two errors, right, on which you can make an appeal. Am I correct on that? Or
Oh, yeah, well, no, we can. So there's two types of appeals, broadly speaking. So one is you can appeal on the law, and they're held to a correctness standard, and there is no law on freedom of thought. So this will be very easy to appeal his decision on the law, because to say he wasn't correct, there isn't any law to even be correct. It's so brand new that is a very easy standard. With evidence, it has to be a higher standard, and but we meet that. He has to make a real error, a serious error when it comes to an appeal on the evidence. But he made a serious error on Professor David Nutt's evidence. He said it's not just those things I told you. He incorrectly described what Professor Nutt was relying upon for his authority. He said Professor Nutt relied upon 5 studies involving 160 people, and he relied upon it's a vast number of things he relied upon, including, but in terms of listing studies, there's about 20 studies and about 1,700 people.
Mhm.
There was a large amount of survey evidence. Um, there were others, but in addition to the studies he explicitly relied upon, he adopted 2 studies as part of his evidence. So all the studies cited in those 2 studies became part of his evidence as well. Um, he what he relied upon, there's a long list of things he relied upon. And actually, where that number comes from, you might be thinking, that's weird. Where did the judge get 5 studies, 160 people? That was from the Crown Factum based on a very early document that was filed, sort of assuming that was the only stuff. But when he took the stand, as I say, he was on the stand for 3 days. He talked about tons and tons and tons of things. And I think what the judge did in haste to write something fast is he just clipped and pasted something from an early document filed by the Crown, and that was his mistake. But because he made a significant error about Professor Nutt's evidence, we can appeal on the evidence as well, and that will be easy because it's very explicit. His error is explicit.
Mhm, mhm. So why would a judge be rushed in this case? Is there that's confusing to me. Would they not have all the time they needed to make their decision?
So we brought this challenge in lower court, as I said, and I did this for some tactical reasons involving my client because he'd benefit more from the result by doing it in lower court. Um, but lower court this is the Ontario Court of Justice in Ontario. It's like a provincial court. Yeah, we have the same in all the provinces, similar versions, and they're really meat grinders. And like every day, the judges have case after case after case, and so they're not really in a position. it's difficult for them. And I think he had a little period of time in which he had a little bit of time off to write the decision, and he didn't get it done. Is my belief. I'm just speculating. I'm
Yeah,
just
yeah.
guessing. But I know part of me, he was a smart man who took the issues really seriously. And he gave, like, the decision ended at the beginning of April. April 4 was our last day in court. And then we got the decision on October 7th. So that's almost 6 months. But I think he just didn't budget his time well,
Mm,
because we spoke for an extended period of time about what happens after I win. And you might be thinking, like, why, if judges telegraph what they're thinking. And I have had judges who have no interest in what happens after I win. And it's very clear that that's not a conversation we have. He'd say, Mr. Lewin, that's fine. I got your submissions. But there was a lot of back and forth about what should happen. And this is a little more technical legal stuff, but this debate. So why would he engage with me for such a long period of time on what should happen if he wasn't thinking that maybe I should win?
mhm,
So anyway, I think that's my guess.
mhm,
In some ways, some of the things he did, he left the door open for an appeal. I think he also appreciated, this is just my gut feeling, that this wasn't a great decision, and that if I'm really serious about this, that let the Ontario Court of Appeal decide what the law should be. And
right. So
so
talk about that part now. How does that happen? What are the next steps?
So the next steps, so I have 30 days from sentencing to launch my appeal. So my client who's out of the country is going to be sentenced on November 21, and I have 30 days to have already launched the appeal. So it's a very short window, and if it's not started, it ends forever, and this becomes the law. Um, I talk so much about the evidentiary record, but the great thing about this is it's all there that we can, when we go, the Ontario Court of Appeal will see what happened, and the error was so obvious, and the
Mhm,
legal issues it'll really be heard from scratch, I believe. And he said
mhm,
a couple of good things. He said two things that were actually fantastic. So it wasn't all bad. Um,
mhm.
so
So what did he say? That was fantastic. Let's
he said
jump
two
right into
things
that.
that were
Yeah,
excellent,
yeah.
which don't matter now, but if I go to the Ontario Court of Appeal, they're going to matter a lot. And that's when you challenge a law, it's a two-step process. One is, does the law contravene either freedom of thought or freedom of expression or freedom of religion?
Mhm,
And if it does, can the government save it under Section 1? And
mhm,
Section 1 is this catch-all section that allows the government to say, yes, we're breaching a charter right, but our response is proportionate to our concerns. So, and you mentioned cannibalism. A good example I often give about cannibalism is, or in explaining Section 1 is, I say, if you had a religion that was a cannibalism religion, um, uh, that and it was really a religion, and you had a holy book on this, and you really met with all these people, and you really believed in it, and you had a big court case, and the judge might say, wow, it really is your religion, but the law would be saved under Section 1 because the government response is proportionate to the concerns.
mhm,
And we can't have that in society. It would be a no-brainer. So,
mhm,
and it's a threefold test, and I won't go through all three steps, but the government, and at this point, they're on their back feet. There's already a charter breach, but they're saying we can save this if we meet all three branches of this test. And the second branch is the minimal impairment branch, which essentially says, is there any other way we could do this in which people could have their charter rights, and you could have the protections you're concerned about? And in this case, the law that prohibits psilocybin is concerned with health and safety. So is there any way you can protect health and safety and people can still experience these charter rights? And the judge found that psilocybin can be safely consumed. And so what that means is, that they will lose the Section 1 test. And I mean, I could talk for 4 hours about why they lose all three branches of the Section 1 test. It's absolute, but I won't do that. But he has already explicitly said they lose Section 1. So if we prove it's a freedom of thought tool, we win. They can't
mhm,
save this law. And so that finding is significant. Um, And the other finding that he made, which was big, is the government often, when you challenge a drug law, which I've done a lot in my life, they will regularly bring up Section 56. A Section 56 exemption, as I bet you a bunch of people on this call know, is a way you can ask the government, can I be exempted from the drug laws? And what they often say is, oh, even if there is a breach of your charter rights, don't worry. What you can just apply under Section 56. It'll be easy. There's nothing to see here. The law is perfectly fine. And the judge said that this is not a viable option here. And they had a couple of witnesses from Health Canada come and express their hostility to psilocybin. One of them said, "We're not." I was saying, "How would anyone even know about Section 56?" And the Health Canada witness said, "We're not in the business of telling people how to use drugs." And so anyway, there was a lot of hostility toward, no love towards psilocybin from them, but that it worked in my favor. And the judge said that's not an option, which was kind of maybe my very first thought when I embarked upon this case is, how do I beat Section 56? And the judge gave it to me. He said, that's no option. So those two findings are amazing. And this judge, it's a terrible decision, but he's not a jerk and he's not a dummy. So I think he's just a smart guy with no time is
Well, and does it make sense, perhaps maybe it's not an overt decision, maybe it is an overt decision to have this decision made at a higher court so that it's not. So tell us what'll happen. So if you'll be taking this to the Ontario Court of Appeal, correct?
Ontario Court of Appeal.
Okay.
And then
So what happens there? What happens if you win there?
so if we win there, the government is obliged to make psilocybin available, create a system where all the Canadians can access it. And they have to comply with the charter. This is not negotiable. And if they don't comply, you might say, oh, the government, like they'll do whatever the heck they want. Well, if they do that, then there will be no psilocybin prohibition. So if they want to keep their laws, they have to comply with this. And so what they'll do is they'll create a system. And I mean, the first iteration of this is going to be probably where psilocybin has to be consumed, probably with a facilitator of some sort. It could be kind of like the Oregon model. You'd probably have to get your psilocybin from a licensed source. Um, but it's the first iteration and it'll evolve over time. And the first iteration of the medical cannabis rules were so terrible. I think you had to get two experts to sign off, which seems weird for cannabis. But anyway, but that would be the system they would create. The so what would the Court of Appeal would do is they'd say the government has one, they'd strike down the law, but then they'd suspend that declaration of invalidity for 1 year, and they'd say to the government, you got a year to fix this. That's how, and I mentioned medical cannabis. This all started at the Ontario Court of Appeal with Parker. So that was the decision. It was the Ontario Court of Appeal that gave us medical cannabis. So they would give the government a year to create a system, and they'd hear all our evidence, and they would take their time, and they'd be very meticulous with it. So there'd be no rushing. There'd be no question of them running out of time. So.
Mhm, mhm. And so you said the timeline for the appeal is you have to make the appeal before sentencing, which is November 21st.
I have 1 month after
1
sentencing.
month. So you have until December 21st to file the appeal. And then we also need to find you a bunch of donors to help fund this, get this going. So why, tell us a little bit more too, like this is, our court, our Supreme, if it had to go to the Supreme Court. So let's say it failed at the Court of Appeal, you would then, would that next be the Supreme Court, or how would that work?
It would. I just don't think it's going to be necessary. I think like on a fair reading of this, I don't know how I could fail short of someone not paying attention, but it would be the Supreme Court of Canada. But I just think all the things I have to prove have been established in the evidence. I had fears that the government expert would claim that psilocybin does none of these things, but they didn't say that. They said it does cause. They took issues, some safety issues. They questioned its long-term effects, but like they admitted, it caused psilocybin the effects of psilocybin are all those things I read. And we had amazing evidence from our experts. We also had an expert on thought, this brilliant guy from Dartmouth University in the States, who talked about the meaning of thought and what is thought. Thought is mental activity, was what we argued. The Crown had this very weird definition of what thought was. They essentially tried to take a freedom of expression definition and apply it to thought. Freedom of expression is all about expressing things, and thought are that's what we hold inside. These are our private matters. We should be entitled to think as we see fit. We talk a lot about the relevance for psilocybin and healthy Canadians using this and how it impacts the psilocybin impact, but this is also important in other ways, and that um, thought is important. Thought itself is important, and there should be a robust definition of what is thought, and also psychedelic thought is important, and that we should have it should be protected under the charter. It's special. This is exactly what freedom of thought was made for. This is not just any kind of thought. This is not any kind of drug. It's a very special drug, and it should be protected. It's great as a medicine, but anybody who's had any experience with this knows it's way more than a medicine. Like I can't. Don't tell me it's just a medicine. It's a lot more than a medicine. So.
Yes. So we do have a Q&A spot on the screen there for anybody who's watching. If you have questions for us, for Paul especially, we'd love to hear your questions. You can put them in the Q&A and we'll bring them up. Don't put them in the chat. I'm not following the chat, so put them in the Q&A tab there at the bottom. And so why are cases like this needed? What purpose do they serve?
Well, it's like the Supreme Court of Canada has spoken about this, that like charter challenges are so important. It's about holding the government to account. And there've been a number of Supreme Court of Canada decisions in which they say, like, this is very important. We should be encouraging, we should be making it easier for people to question government laws. This is how we keep them in check. We have the role, our charter is the highest law of the land, and all of the government's laws have to be in accordance with it. And so it's the only way these checks will happen is through constitutional challenges. So I think it plays a very important role in holding governments to account and not letting an ill-informed majority boss around a minority, perhaps. Although psychedelics are so widely used, I'm not sure. It's probably still a minority, but part of the evidence too, by the way, was the vast number of people who use psychedelics every year in Canada, and I
Mhm.
think the number was around 2.5 million,
Yeah.
which is huge. And by the way, this is not just about psilocybin either, but it's about all psychedelics. Psilocybin has tons of evidence supporting it, but like this is going to flow to other psychedelics too. Should just be the beginning, not the end.
So we've been told, well, we know that our courts are also activist. Like we have activist courts in a way. So that's a good way, right? Because otherwise we really wouldn't have, without referendum laws, we don't really have, there's not a way, there's not citizen, we don't have a federal citizen ballot. We don't have a way of the citizens can say, hey, we can bring petitions in parliament. We can do the e-petitions and have our petition read in parliament, but we really don't have a way beyond voting every approximately 4 years to ever really influence what
Yeah, no,
legislation,
actually,
what
that's a
the laws
great
of
point.
the laws of the land are. So the real only way is for a citizen to go through the courts and at great cost to themselves. I can't imagine how much it's cost so far.
Yeah, no, that's a great point. We don't have that. The Americans have that. We don't have that. All what we have is the only thing we have other than begging and lobbying. And so, could you please help us? Could you please be reasonable? Is a charter challenge. We don't have those citizen initiatives that they have in the U.S.
Hmm.
Um, and we
Hmm.
saw that with cannabis too, where our charter moved it forward, but down there it was the citizens initiatives in, I guess, Colorado and Washington that really
Hmm.
paved the way.
Hmm. So a number of questions have come in. Since we're talking about money, first off, what is it going to cost? What does the appeal need? How much money do we need to help you raise to get
So the grand total for the appeal is 150 grand. That's not all going to me. That's There are some things I have to pay for to make this happen. So, but that would be the amount. I have spoken to a donor, in fact, earlier today, who will put up some money, maybe around 15 grand. So, like, it's beginning to move forward. There would be full transparency on everything in terms of the money, and on the case, and I would work on it like a crazy person. Like, I would work on it night and day, and my fees are like, it's given the amount of time I will spend on this, it's modest. It's not a windfall, and I know if I'm asking people to help with this case, I have to make sure I'm billing at a modest rate. This can't be a payday for me. This can't be, oh, this is going to be great. It's got to be where I take a little bit of a hit too. So,
Right. Well, we're going to get that details from you where how people can make donations, how they can do that. We'll get that and we'll make sure we put it in the chat here. So what happens if the client can't come back to Canada? What happens if
so
he
yeah,
does
and I should mention he left because of fears for his safety. It wasn't.
in Canada?
Yes, yeah. So it wasn't because he was trying to avoid the case or he wanted to go hang out with a friend in Egypt. He left for safety reasons, and this has been something that's been discussed to a great extent in the case. And that's an unusual feature of it. And so in terms of him, I expect there's going to be some fine that's going to be levied against him on November 21. And so that's his that's his situation. That was another call. There were a never endless series of complications on this case, but it was also
Does it stop the case going forward if he's not in Canada?
it looks like it will not. It looks like it will not. So if he if so, I think things are set up so that it will not. And I won't go into greater detail, but
Yeah.
as it stands, it will not. And by the way, I'm not going to receive a penny from anybody at any time if this appeal does not go forward. Like, I'm not accepting, like, if like that's not if I receive $1, I am doing that case. Of course, I'd need more, and if I received it and it didn't happen, I'd refund the money. Um, the way it looks right now, it looks like it's fine. That's a great question, and that's something that we've discussed to a great extent in court. But I think we're fine to do the appeal. I think that there's a sense from the judge that this should be appealed. We all realized that this was brand new, and like, it's brand new for psilocybin, but it's also brand new for law because freedom of thought is so brand new that it's never been argued. There's been a million freedom of expression cases. I could fill my law office with them. There's been lots of freedom of religion. Every charter right has been argued endlessly because lawyers are always arguing something. But freedom of thought has never been argued before, and it's the perfect thing to argue it. Uh, it's something so special as psilocybin.
Yeah. A few more questions here. So I'll read this one. I've heard mixed feedback from Health Canada. How can we get alignment with this agency to support legalization? Are they just overwhelmed and too underfunded to support this initiative?
I've dealt with Health Canada for many years, even before psychedelics, with Health Canada or with cannabis. I was always dealing with Health Canada, and there will be no support. They work within the system. They don't change the laws. They are only bureaucrats. They don't decide on what the law should be. That's for politicians. Um, but I say this, I don't say it with disrespect to the people who work at Health Canada, but we will never get, like, trying to cajole them into being reasonable. That's not going to happen. They just apply the law as it stands. So
Yeah, and I think that's what most people like. Health Canada doesn't make those rules. They follow the rules and they follow them within that process of, and I think, we've all had side conversations with a lot of folks there at Health Canada when they're not wearing their Health Canada hat, and it seems like it's two different. It's almost like two different personalities. One there and one outside in what the real world is, and it's too bad you can't bring those together a little bit more. But they're not so somebody asked, like, why are they so hostile? I don't think it's so much they're hostile, it's just they didn't probably sign up for the deluge of applications that were going to come their way after the first successful Section 56 application. and that door opened, and then all of us MDs and people were like flooding them with applications for people that also had a right to psilocybin therapy,
Yeah.
and
Yeah.
then shuttled over to the special access program now. So they're simply not the decision makers. They're just the doers of that.
Yeah. Nice that you say that though, because we don't need to beat them up, but they will
Oh,
never agree.
yeah, yeah. Another question here. Would I be correct to guess that you brought up the extensive research done on the neuroplasticity of the brain with psilocybin, particularly with depression? And if so, could the judge understand the correlation to thought and for healing transformation through neuroplasticity?
Well, number one, absolutely I did. And that's because of the brilliant people I was working with. And it was found there were that that is part of thought processes. That is a freedom of thought effect, the neuroplasticity that comes about from it, and the medical effects. You know, you can describe those medical effects as like I focus completely on thought, but there's such a correlation between having these important mystical experiences and getting better that I don't think like it's great for healthy people, but really freedom of thought is also at the heart of the medical benefits. So, but I don't want to, that kind of blurs the line between the two. But to answer the question, absolutely, we brought it up. And in fact, a number of two experts said that there is that link that when you have the mystical effects, you tend to get better. It improves your depression. So I think I answered the question, but
Yeah,
it's a good question.
yeah. Okay, so so many questions, good ones, great. Thank you, everyone. Keep putting them in here. How from Janice, how did you couch your argument? Are you suggesting inhibition of thought in Canada is in any way deliberate, as might be implied by the history in the US of targeting peaceniks, for example? Does that make sense? How did you couch your arguments?
Oh, and whether it was deliberate. Um, I, I personally think so. The law we attacked is the prohibition on um, psilocybin for sharing or selling psilocybin, and we said that you can't if we targeted psilocybin prohibitions. But I don't think though, I truly think that those laws were created at a time when no one the knowledge that people had about psilocybin was almost zilch. And
Mhm.
some people had a lot of knowledge about it. So I'm not saying everybody, the general knowledge was zilch, but I think the lawmakers knew nothing about it. And it was during the war on drugs era. And they just said, well, sounds like another scary, weird drug. Let's prohibit this as well.
Mhm.
So I don't think this
So,
prohibition was
mhm.
intentionally designed to mess with psilocybin. I think they never thought about it, but as the person who asked the question raises this, like this does have implications for all kinds of other things that like the crown definition of thought, and it would take me 10 minutes to just describe it. It was such an awkward, weird definition in which if it wasn't part of it was it had to be intellectual content. So if I'm just thinking and I had to form, as a result, I had to form an idea. Thought is important, and governments can mess with us in other ways over thought-related issues. So there's many, and our brilliant expert on thought talked about some of the different ways that kind of borderline totalitarian or really nasty governments try to impact thought. So,
Mhm.
like, this is not just about psilocybin. I know I said that a minute ago, but that the person who asked that question kind of raises that this is even bigger. That it's really important that this is a sacred space that we can think as we see fit, and that the government has no role in here inside our minds and it's a private matter that we can never to disclose.
And it's from what you said earlier, and we have and the argument is that we can use the tools we wish to have freedom of thought.
Yes, yeah. And there's different ways
So
thought
is
can
this,
be impacted. So I don't deal with, like, for example, when a government law tries to um, learn what you're thinking, that would be a different test. I deal with just when you have a freedom of thought tool that you're being prevented, but we do use a very broad definition of thought. We say that that is mental activity, and that's important for thought issues going forward. And that wasn't accepted. Again, the government took the judge took this terrible, terrible definition of the Crowns, who almost, during my final submissions, I spent about an hour and a half talking about what a terrible definition it was. And then when they finally got up, I almost got the sense like they were like saying, all right, well, like they almost seemed to abandon their terrible definition, and he clipped and pasted their knucklehead definition into his judgment. But yeah, thought alone is important.
so and just a clarity for that, the freedom of thought is in the charter.
Yes,
Yes, I
absolutely.
just want to make sure people like this is in our charter. It's already exists. And what you said earlier is that just no one's ever made this argument yet. So
Yes,
no one's ever
section
said we
2B.
have this right in our charter, and no one's ever used and gone to the courts and said you are infringing on our charter right to the freedom of thought. And this is, so you're the first one to, this case is the first one to go to the courts and say the government, by not allowing us to use a tool of psilocybin mushrooms or psilocybin, I guess in whatever form, is infringing on that charter right.
Exactly.
Okay, just wanted to make sure we had that, because we have, it is a protected right. It's just that,
Yeah.
there you
Yeah.
go.
No, it's like expression and religion. This is not a some weird thing that I cooked up. Like, you open up the charter, section 2B is right near the beginning. It's the very beginning of 2B. And the profoundly important things people have said about thought, like some thinkers have described it as the most important of all rights. Because what do we have? Do we have expression if we can't think as we see fit? Do we have freedom of religion if we can't think any way we want and use any tool we want to change how we think? Um,
Right. So really a great opportunity for everyone watching to hop on over to Google and Google what is in our Charter of Rights in Canada. You should know this. This was probably taught in high school, but you should all know this. Okay, so more questions here. Is there a discussion with PAC and among legal advocates about creating distinct frameworks for medical, spiritual, and cultural access, ensuring traditional medicine paths aren't forced into a pharmaceutical, clinical, or commercial mold? The current landscape seems to be solely focused on psychedelic therapy and very clinical.
yeah, I love that question. And it does seem to be very focused on psychedelic therapy, and there is a bit of a pharmaceutical spin, which is coming from Health Canada too, because they love their powders and pills, and they don't like natural stuff. And so, and I think the question you mentioned, I heard cultural, and what was the other one?
Oh, they've already taken it off. It's
Oh,
gone. Just a second, right? Let me get it back. So it just, sorry, give me a second here. So ensuring traditional medicine paths aren't forced into pharmaceutical, clinical, or commercial, or the commercial mold. So this is
yeah.
this
I
is what
mean,
happened with cannabis, right? So cannabis kind of got shoved into the medical, which then in a few more years later, or however many years later, then opened the door, and now everyone can grow 4 plants at their home. You can use cannabis however you want, as long as you are not harming others, essentially.
yes, yeah. Yeah, no, so those are all a whole bunch of good points there. They make that it should not just be about medical. If,
Yeah.
and you know, our the question of wellness, this is something actually Professor Nutt brought this out so beautifully, but like no one, I don't have treatment resistant depression. I haven't been diagnosed with an anxiety disorder, but you can't be a lawyer who goes to court and not feel anxiety and sometimes feel depression when it doesn't go your way. And just, you can't be a human on earth and not feel anxiety and sometimes feel more depressed than you should be and feel crummy. Like, we all feel this. And so just feeling better about, if there's something you can, an experience you can have and you can feel better about yourselves, this should not be a question of medical or not. And I know some people, it's their health, it's so serious and it's so special that they can get treatment, but we all could get better.
Mhm.
And I know some people say, and I kind of slammed the word medical, but in a way it's medicine for all of us. And I think some people use it in that way as well, that when they say it's medicine for all of us, whether you're however well you define yourself, it is medicine for all of us. And so it's something that makes everybody feel better. Um, and so that's an amazing thing. And it could be a cultural thing. I could feel more connected to my neighbors. Oh, some of the evidence I heard, it almost brought me to tears. It was so powerful. People, we had some civilian witnesses who talked about, there was a member actually of PAC who testified, and it was so powerful. And she talked about a family member who she had issues with, and this amazing experience, and how she forgave this family member. And actually, there were a couple of witnesses who talked about forgiving people who they had issues with. So to like say, is it medical or is it a religion? Because that's all we got here in Canada. That's ridiculous. That's so simple-minded. So
Yeah, and I think it's a discussion that we all want, and that is one of the tenets of the Psychedelic Association of Canada, is to bring in an evolution of wellness. That we don't need to be a sick care country. We don't need to be only reactive. That don't isn't wouldn't it be a better to foster a healthy mind, body, and spirit, and be able, and I think I'd be pretty safe to say that most people's first psilocybin mushroom is absolutely not medical, is not treatment, is quite likely a camping trip or something like that with friends, laughing around a fire, or, and community bonding, uh, with friends or colleagues, or with a family. And why wouldn't we want a society that is healthier, that can let go of their grudges, can deal with trauma immediately, and not have to wait till it becomes so medicalized that now you're in the system? And we've made this argument many times to police chiefs and fire chiefs, like, wouldn't it be nice that your members have these options, to have these opportunities to experience these medicines at the beginning of the job, so they start the job healthy? And then, you know so I think there's a strong argument, and sometimes it's going to be business and medicine and pharmaceutical that runs the show. But I guess the call here is that Canadians need to speak to their members of parliament and their MLAs and make their voices heard, as well as what they want.
yeah, no, for sure. I often get asked, why did cannabis get legalized? And I think it was it's not just court cases and it's not just studies, it's protests, it's calling politicians, it's civil disobedience, it's talking to friends and neighbors. So it's lots of things.
Yeah, all hands on deck. You got to tell people what you want, right? We have to stick our necks out and speak up. I mean, if we hold a democracy. Um, let's see, there's some, since I don't understand that question, I'm going to go to the next one. Is there a fear for politicians or the court system to be the first to allow this progress? And maybe I'll tie that in. This is from Mandeep, but I'll tie it in, like, how does that work with the UN declaration? Like, how, I mean, I know Canada, we went against it. We announced that we were going to legalize cannabis. We broke the UN convention. But anyways, is there a fear for politicians or the court system to be the first to allow this progress?
Yeah, so and you're right. We signed these various conventions in which we said we'd make drugs illegal forever. But they're international conventions that we signed laws to make them, that we try and do our best to abide by them. But all of our laws are subject to the charter. So the charter is the highest law of the land. So when we promise to abide by a convention, that takes second place to following the law, following the charter. So the charter always comes first, and all over the world, like where there are so many exceptions. These conventions for war on drugs conventions are so backwards. Like it's like anyway, they're not that's. And you're right. We just thumbed our nose. I've heard some gobbledygook about how cannabis somehow were in compliance. That was just straight up legalization. Like there was no charter requirement to legalize at all, and they just did it. There is not. We're gonna just do whatever we see is fit, and but ultimately we will win. I wanted to touch on something else that question raised too, and that's judges and politicians being brave. Well, we know politicians, that's not their strong suit. Judges, it's such a thing when I bring these challenges, the type of judge you have, like there's really a lot of judges because if he had struck it down, like everybody in Canada, especially in the legal community, are looking at his decision and scrutinizing it so carefully. But he rejects it, and now no one will look at it. I mean, some will look at it, but he brings a lot of attention, so it does take some bravery. I think this judge was brave. I don't mean to say he wasn't. As I say, my theory is not that, but courts of appeal, they'll do whatever the heck they want. They're not afraid at all. So,
Well, it sounds
and
like he teed it up for you, really. Like he gave you a strong case to appeal. You have strong evidence. Now you're going to have it at a much higher court level, so that that decision will be even stronger.
yeah. And I think there was a sense from him too, like you brought all this evidence, like surely this has got to go to the Court of Appeal. Like, were you, and if I had won it, they'd appeal it to the Court of Appeal. So he's just saying, go
Either
let them
way,
decide. And I
either way,
won't put any
going,
hurdles in front of you. I'm not going to stop you. I'm going to
yeah,
make it like a clear path for you. So,
yeah. Either way, you are going to the Court of Appeal, probably.
yeah, yeah.
Yes, yes. Okay. We've asked, I think you already answered this, any relevant international jurisprudence, but I think we've already answered that with the UN.
Well, like there was this thing. Shoot, I wish I could remember the name of it. So there was an important document, not the international conventions we talked about, but in the thought context, uh, on what is thought. The UN had shoot, the name of the document escapes me, but the UN had formed a committee about 10 years ago. In fact, my expert was on that committee in which they decided what does thought mean, and there was a whole lot of discussion about it, and it was mostly positive, and there was a little bit of reference to psychedelics in there. It was about very little, but it was, and my expert made clear, it's just not something that people had got their heads around yet. Like no one had said that's not a freedom of thought tool. They just didn't know enough about it to form opinions on what it meant. And there's a few quotes in the decision which they take that document out of context. And so there is an important document, but it really doesn't, it's a very open-minded document that doesn't really say anything in particular. So.
Okay. So how are people going to help fund this? We have some questions about, is there a GoFundMe campaign? How is money being collected? And if you don't have one, I think we're going to start one for you.
Yeah, I need to do that. I don't have
Okay.
one.
All
I
right.
feel
Well,
so
we're going to
stupid. I raised this and then I don't, you say I'll put it online. I don't have one. I'm really low tech. I'm older than I look. And so I'll have to
we're going to
speak.
help out with that. We're going to get that going, and we'll make sure that the link gets out to everyone that came to the webinar. Um, and we can spread that, we can amplify that out there and get that spread through social media. But we'll get that, we'll talk about that offline, and get something happening so people can throw in some money to this, because it's obviously very important. Now I don't know
Thank you.
what this means, but I'm gonna read it out. Is the case on can l I
Oh,
L11, sorry, I don't know what that means.
I know. It's Can Lee, actually. It's a great free legal service. Um, It might be. If not, I'm going to put it on my website very shortly. I have a kind of a discussion about an analysis I just completed, in which kind of describes the different ways that the judge went wrong and explains the case. So I'll make both of them, but I bet you it is on Can Lee. Um, so but I prefer, and I'll try and put this out. Maybe I'll get it to you afterwards. It's not yet up on my website, but hopefully by early next week, I'll have it there, because I hate people reading it without seeing the analysis. It's sort of like, man, that Lewin, didn't he do anything? This, I just like, if you just read the decision, it really looks like I barely tried, and it was an epic effort. And it's more than just the experts who were in court. I got so much amazing help from so many people.
Mhm.
There is a very long list of amazing people, some of whom I am talking to right now, who are amazing. So, um,
Well, it's an important case, and I think it's something that people are really interested in. They want to know what's happening. So many people, psilocybin has affected their lives. Other psychedelics has affected their lives in many in impactful and meaningful ways. Brought them closer, helped them deal with their traumas, brought them closer to family members, or help resolve grief. there's just so many things. And I mean, ultimately people want a good life. They want to feel better. They want to be engaged. They want to sit around the barbecue and chat with friends or go for runs in the forest and live life and not be struck in with things where, in bluntly, as a physician, we have a lot of great tools, but we don't have a lot of great tools when it comes to a lot of things. And so we do need these bigger toolboxes. So this work is really, really important. Another comment from one of the viewers, just a comment perhaps to bolster the case. Thought is so important in pain control, and with psilocybin, I was shown how to deal with chronic pain and changing how I thought about it.
Oh, well, that's interesting. And I have a few clients slash friends who struggle with pain, and they get such relief from psilocybin. That's interesting. Yeah, you know what? And and there are many different types of benefits, but like it's just like it just does. There are all such great things that it does, and and they kind of make us all like. Um, Anyway, I'm repeating myself and I'm saying stuff everybody knows here, but that's interesting. Yeah.
Well, and it's good. I mean, what is good is that there is, I didn't know that it was as high as 2 million that have had an experience with psilocybin, but we know like in 2023, 8 million Americans had a psilocybin journey. Like that's a lot of people, and it's probably much higher. It's probably closer to 12 million last year in the US. So, we could extrapolate and think that maybe that means 1 million or so Canadians likely had a psilocybin journey. And I think these issues are, especially once kind of thing, and once you've had that experience, it really changes how you think about this. And it really changes also just this, how many of us grew up with the war on drugs. And this is your brain on drugs with the two eggs frying in the pan and just say no and all that stuff. And knowing that there was no evidence and no medical evidence for any of that stuff, that it was purely propaganda. So I think there's a lot of people leaning into this. What is some more questions here? Why do you think this, oh, good question, why do you think this route has never been used before when it seems like such a reasonable pathway?
Yeah, I like that question. So so there's a couple, there have been cases that have brought this up, but they bring it up in the context of freedom of expression, which is very common, or freedom of religion. So there'd be an issue and they'd say, and this also deals with freedom of thought, but they'd never go hard on freedom of thought, and it's decided on freedom of expression or freedom of religion. There was one case, from about 25 years ago around Remembrance Day in Manitoba. And I mean, no one, they didn't go hard on it, and ultimately was decided otherwise for other reasons. I don't know why no one's, I don't know why, but I think maybe, I'm not sure why. I'm not sure why.
Okay, well, you're a trailblazer, that's why. Okay, okay, are there any other cases before the courts that may have a bearing on this issue?
Um, I mean, I'm a part of another psilocybin case. It's medical, but it's really just about medical access. It's not broad. It's not gonna, doesn't have the implications this has. I don't think there is anything else out there um,
You have
that.
you had one before though, right? For cluster headaches. Were you involved in that?
That was, yeah, I was not. It was a
Um,
judicial review. It was so that, but no, I wasn't involved in that.
because
So
that also went through the courts
yeah,
or
yeah. I mean, there's been a little bit of court stuff around medical, not a ton. Actually, there's no constitutional rule. A little bit. There's been some stuff. Nicholas Pope has had a success with healthcare professionals getting access. That was probably the most significant decision, but it's only been medical. It's only been medical.
right. Okay. And what is a reasonable time frame for the Court of Appeal and a potential win? So you file your
Um,
appeal, what?
Yeah, so we have to, as I said, we file our notice of appeal by December 21. Then we have to do the I would have to draft a factum, which is essentially all our legal arguments and all the evidence condensed into a jumbo document. That's at the Court of Appeal. That's a super important document. And then I have to create a record, an appeal record, which is all the documents that were filed in the case. A lot of studies were filed in the case. So it's going to be a giant appeal record. So I put all those things together. Like putting all the stuff from the court is really simple. It's really the factum and framing this, because that carries a lot of weight at the Court of Appeal. Like they will go in there with strong feelings in advance. So to answer the
So
question, I'd
the
sorry.
factum is then going through all the evidence and outlining the argument.
Yes. So you take all, so it's all the legal arguments and it's all the evidence, and both of them are vast. The legal arguments were vast. The Crown there were three crowns against me on this case. It was me against three crowns, and they had a 72-page factum, which is like for a lawyer, a 72-page factum is insane. At the Court of Appeal. So anyway, you have to take, so the legal arguments are vast. And you have to condense it you have to make it as tight as you can. So it's kind of like editing something is tough. Like taking a lot and squeezing it into something tight is tough and not losing arguments. The Court of Appeal, you can ask for permission to file a long factum at the Court of Appeal, and we'll absolutely need to file that, do that. So anyway, to answer that person's question, we're probably looking at maybe about a year from now that the appeal would be heard. That depends on various factors, but I guess about a year, and then it could take about 10 months for them to write their decision. They will be super thorough. It'll be a panel of three judges. This issue will get us heavyweights. So, like, not every Court of Appeal judge is a heavyweight. They're all very serious people and they're very smart people, but there are super heavyweights, and then there are just good judges there, and we'll get super heavyweights dealing with this. And so yeah, that's the timeline. So it's a little drawn out, but we're already like this fight took me. I started this fight 2 years ago, so we're well on the road, and that's why it would pain me so much to lose what we've done and to start from scratch, or even have a court say, well, it's already been ruled upon, with this very slight decision.
Right. Okay. Well, we need to make sure that happens. How can we access the pleadings, written arguments, expert affidavits, etc., from the court proceedings?
Oh, I am so glad that that question was asked. So I have an analysis, and in there I cite other experts, our experts, like all these things I say about Professor Nutt, like I say where it is in the evidence and the transcripts. So I I'm gonna put, so I'm gonna start. I've already got his permission to put all his transcripts and evidence up on my website, so I'm gonna put it up there. So when people get this analysis, I'm like, I footnote a lot of things and they'll see where all these things are. And I'm going to try and put everything on my website. So I just have to get permission from different people. And in my low tech office, get my assistant to put all these on my website. But yeah, I want I want the truth to be known. That's what I
Mhm.
want. So I'm going to make it widely available to everybody. And that's a great question, because it's not just the decision. It's not even just my analysis. Like you really need to see what was actually said in court,
Mhm.
and what were the documents that were uh, filed. So yeah, it'll take me a little while. First thing is going to be Nutt's evidence, but it's all going to be available. So the truth is
Okay.
out there.
So we're going to make sure we'll help you get that out there too. So as
Thank you.
that gets on your website, we'll make sure we get it out there in our newsletter. So keep an eye out on the newsletter for access to this. Janice asks, is there any room to argue arbitrariness? Morning glory seeds are a known hallucinogen, but they do not seem to be restricted by the CDSA. I imagine the same is true of many other hallucinogens. There's a ton that grow and are not restricted. So is this arbitrary, that psilocybin, or is that?
Um, yeah, so arbitrariness. That's kind of from the medical arguments are under Section 7 of the Charter. And so Section 7 of the Charter provides that you have life, liberty, and security of the person, and not to be deprived thereof, except in accordance with the principles of fundamental justice. That's a mouthful, but essentially, this is the medical section that people use to make medical arguments. And so this person who argued this is saying that life, liberty, or security of the person. For a unwell person, it would be security of the person. You have the right to control
Mhm,
how you're going to treat your serious health issues,
mhm,
and liberty is jeopardized actually with any law that can send you to jail, and life, if your life is threatened and you can't treat yourself as you see fit. And then the principles of fundamental justice, arbitrariness is one of them. Is the government taking away these laws for arbitrary reasons, or taking away these rights for arbitrary reasons? That wouldn't apply so much for us because we're 2B. So it's just a straight up question of, is this freedom of thought tool?
mhm. Okay. Um, what is the date of the, oh, I think you already answered this, the date of the decision and the name of the defendant? Oh, I guess they're asking to look it up.
Yeah, so decision was October 7th, and the decision, and it was Samer Akila, Samer Akila, is the what's the difference? R versus Aquila is the name of the decision.
Okay, another question, that wouldn't it also be wise to go to the vets? You think, I guess your argument here for freedom of thought doesn't matter who you are. It's that's ubiquitous across all Canadians. So just focusing on a certain population like veterans.
Oh, um, yeah. So when you challenge a law, it's not about, it's about the law. It's not about the person. That's not a crazy suggestion though, that anytime you mount a constitutional challenge, it is good to have a person who fits well, like a good representative person. Um, I mean, I didn't, Mr. Aquila, he wanted to do this, and so that's why I did it with him. But ultimately, it wasn't about him. He didn't testify on the case. Um, and he cared deeply about these issues, but he just couldn't testify, because once he's up on the stand, they can ask him a million different questions. He just couldn't testify, but he was passionate about these issues, and so it is from an optic standpoint. There are advantages to having the right people, but ultimately it is about the law. That's on that challenge. It was all about the law. It's not about. It wasn't really about Mr. Aquila at all. Much as the government tried to make it seem like it was about him, it was not about him.
Right, right. One of the question is mentioning the movie Dosed, and that this information is out there. Of course, this information is out there. I mean, across, and it's a great thing to put a kudos out to the filmmakers that got Dosed out there. Storytelling is always so powerful to really see. Um, and our program, the nonprofit In Roots to Thrive, has also had multiple successful Section 56s early on, and many SAPs, but that's not really what we're talking about here. Like, that's a medical process. So there is this medical process on a case by case basis for physicians or nurse practitioners to apply on behalf of their patients right now to get access to this. But um, I imagine anything that would have been in that would have also already been in the evidence from Dr. Nutt and your other expert witnesses. So they're well aware that these medicines not only help Canadians who are suffering from what would be considered something that could go under section or special access, which would be treatment resistant depression, end of life distress, cluster headaches. But what we're really arguing is that you don't need to have one of those to have access to psilocybin.
Yes, yes, absolutely. And I touched upon this earlier, though, and at one point in the Crown's final submissions, they said, by the way, people who have derived health benefits um, from psilocybin, like that doesn't count. This is not a medical case. It's not a medical case, but like if as a result of your thought-related benefits, your health improves, that's a thought-related benefit. Like more than one charter right can be engaged. So it's not like, oh, medical only fits in Section 7. It can't ever be in Section 2B. More than one charter right can be engaged.
Yeah, more than one thing can be happening at the same time. More than one thing can be true at the same time, and you can. And of course, your freedom of thought. I mean, that is such a fundamental part of health and wellness. If we had that taken away, I mean, you can see what happens when people have that taken away from in authoritarian situations.
Yeah, yeah.
which we don't want to be in. Let's see. Due to the legacy of prohibition and the war on drugs, are you finding research gaps exist that complicate the process of arguing this case? And if so, what are some of those gaps?
Yeah, so I mean, there is a lot of research going back a long ways. Like there was, as everybody knows, there was a gap in the research. So there was tons of research in the 50s and 60s, and then it kind of dried up. I'm not exactly sure, but maybe in the beginning of the 90s. Pam, you might know better than me, but it was sometime around the late 80s or early 90s, it's completely stopped or got down to a tiny, tiny trickle. And then it kind of restarted in the early 2000s. It would have been great if it had continued during that time. So for sure, prohibition has and I've heard such awful things about too, so how prohibition caused some of this research to go sideways. Uh, um, I'll just tell you one tiny anecdote, which I found just astonishing. So Professor Nutt told me this. He said that in some of the early studies, they would tie people to a chair and give them psychedelics and see how that went. Um, and he said like he believed that was really with the intention of having a bad result. They weren't like ignorant; they were rotten. Maybe I got that a little wrong, but I think that was the anecdote. But anyway, yeah, prohibition has done all sorts of terrible harm, and it is an uphill battle in court too, where judges kind of there's old school judges out there still who aren't
Mhm.
are need a learning. So.
Yeah, and I'll give a little shout out to another previous webinar guest who is Erica Dick, who is a fantastic Canadian historian. And if you really want to look at some of the history around treatment and therapy, pre-war on drugs, she's done a great job of bringing out archives of what happened in British Columbia, in Weyburn, Saskatchewan. And so I think every book that Erica Dick has ever written should be read by everyone in the psychedelic field. She's absolutely a great writer. So some information there. Jillian asks, what keeps you going? This is an enormous task. You're doing it without any, compensation. I mean, or very little compensation. I mean, you can tell that this is coming from the heart so much and the drive to really do this well. But what keeps you going with this? Why are you doing this?
Yeah, well, it is exciting for me as there it's exciting in two ways. It's exciting as a lawyer doing this new charter issue that hasn't been argued before. So that is like some of you might be saying, "What? Like this is really an exciting thing for a lawyer to argue a charter right that's never been argued before." That's amazing. And of course, psychedelics are amazing, and I am a true believer and like the stuff about the mystical and the spiritual. um, I have had experiences which are everybody religion like there's certainly very very special things that can happen during a psychedelic experience. Everybody on this call probably knows this, and it should be getting its respect and treated in a special way, just the way we treat religion. Um, so, um, but
So if you had the magic wand, and you got to write how this looks, so the appeal case wins, and how does this roll out? Because one of the previous questions came like, what if this is just another full-on medicalization or pharmaceuticalization, and we're not really honoring that there's other ways of using these medicines for spiritual growth, or perhaps just not just take that word out, but for creativity, for just wellness, nature relatedness, uh, couples counseling. Like you can have the whole spectrum of that, and the worry that it may go through and be completely medicalized with all sorts of, we've seen that, in Oregon, where there's these handoffs where your therapist is not the one who can give you the medicine. It's, and we end up in these absolutely ridiculous protocols versus just something where you can be in a beautiful setting. So Anyway, all that to say, what do you hope like you win the case? How would you like to see this? How would you like to see this come out and roll out in Canada?
Like I'd like to see a system where, of course, if you've never done it before, maybe you should have a facilitator present. But some people have done it lots of times and they don't need a facilitator present. You should be able to, there should be lots of variations on this. You should be able to, maybe you have one-on-one with a therapist. Maybe you can go to a retreat and be in the woods. So it could be a nature-focused thing. You don't have four walls around you. You're in nature, which is such a perfect place to do it. Maybe you've done it enough times that you have experience that you don't need a facilitator at all, and you could just say, "Listen, I'm going to be using it," and you fill out a little form, or maybe you've done it enough time. We can have a little bit of trust, and we can treat people like adults if they have experience with it. If you have limited experience, you need some preparation. You need maybe a more full-on controlled experience in terms of the substance. Will it be natural whole mushrooms? It should be able to be where you can opt for that. I don't know if realistically that may not happen, but it should be something where you can say, listen, I'm going to use natural mushrooms. I'm going to get them from this source, or maybe I'm going to grow my own. So it'd be something where you can opt out. There'd be some light government control. And maybe certain situations, like if you've never done it, then maybe you get a little less, like you kind of having experience with it. I heard a good line from I think it was I can't remember who said it, but a really good line about it's like a pilot's license. Like as you gain more experience with it, we recognize that that experience matters. So something like
So
that,
if you
which
have to align that for all of it, like that would be your alcohol introduction to, given that, Dr. David Nutt was one of your expert witnesses, and his 2010 Lancet article puts alcohol right at the top and mushrooms right at the bottom.
well, we had a whole bunch of those. We had about three or four of his, which didn't get mentioned in there. Someone I saw put the decision in there. Please read my analysis and just like hold off before you judge me too carefully. That's not mentioned at all. His those MCDA multi-criteria decision analysis, and absolutely mushrooms. They list all the drugs and mushrooms at the very bottom. And
Yeah.
is alcohol at the top?
Yeah, alcohol and heroin. I think I read that one, the top two. I could be wrong, but yeah, right down there. So there's been a lot of great links in there, but what we're going to do, what we're going to commit to, we're going to get some more information from Paul. If you haven't signed up for our newsletter, please go to the website and sign up for our newsletter, so that when we get all these links from Paul, and he's got his website all updated and ready to go, we'll blast this out to the newsletter so you guys can see this. Equally, if you're not a member, please consider getting a monthly membership or a yearly membership, or even a bigger supporting membership. It really helps us keep these going, and bringing people like Paul back, and keeps the hamsters running in the background. So we really appreciate that. So we'll get that out in a newsletter. We'll figure out how we can get some information out so that we can get some funds coming in, so we get this very important case funded, so it can be properly argued at the Ontario Court of Appeal. Anything else you want to add before we thank everyone and we let everyone go?
Yeah, I just want to say, like so many people, Dr. Crisco, you helped me. So many people, Paul Stamets helped me. I saw Mark Goldgrub's name on there. He helped me. There were a whole bunch of lawyers. I talked to so many people who had powerful personal experiences, and I didn't end up using them as witnesses. I just I mean, that's the amazing community. All kinds of people helped in all kinds of different ways. There's experts on here who talked to me, who spent a lot of time talking, and then we went in a direction. But my thanks to the amazing community that helped. So
And that's one thing that I think why this community is so beloved, is like we care about each other. We want the world to be better. We believe people should be kind. We believe in progress. We believe that things can be better for everyone, and that we have these tools. And it's, the psychedelic community is one of the kindest, nicest communities that are willing to do the heavy lifting. And you're really doing that. You're really one of the true heroes. This is heavy lifting. This will be in the history books. We're all going to be here with you, walking with you, lifting you up, and helping in any ways we can. And so just really a huge thanks for the effort that you're doing. It's a lot of work, and it is really the hero's journey.
Thank you very much.
All right, everyone, have a great night. Thank you for joining us, or afternoon or morning, wherever you are. Please sign up for the newsletter so we can get you all the updates from Paul. And any of the other lawyers out there, you got updates or cases that are going through, we'd love to help publish or get those out there to everybody. Keep some eyes out on some fun stuff coming up with the Psychedelic Association of Canada. And, go out there, be kind, have fun, and let's make this world a healthier and more well and a little bit more fun. So thanks, everyone. Thanks, Paul. So much gratitude for you being here today.
My pleasure.